Welcome everyone to the Countdown to Compliance presented by Tom Revnew at Littler Law. I'm Chris Davis from the Printing Industry Midwest, and we hope that we can get you some great information here today. If you'd like to, you can leave questions in the Q&A. And we will try to get those answered for you. Tom may be looking at the Q&A, or we'll get them answered at the end. He will also stick around at the end if you have questions as well. You can also use the chat function. Both I and Ben will be watching to see if there's anything that needs to be attended to. So thank you for joining today. I'm now going to pass it over to Tom Revnew from Littler Law to present Countdown to Compliance.
Thanks, Chris, and good morning, everyone. This is Tom Revnew who is speaking. As Chris mentioned, I'm a shareholder with Littler Mendelson, obviously a frequent presenter for PIM events. And today I'm going to talk about how to comply or prepare to comply with Minnesota's paid family medical leave. And frankly, there's been quite a few seminars, webinars that I'm sure many of you have attended as it relates to paid family medical leave. And so some of what you are going to learn today is going to be an overview of items that you've already learned, but I will be covering briefly who's covered under the paid family medical leave, what it covers, how it works, and start talking about things that you as an employer should be doing, which includes looking at integrating your various policies, whether it's federal family medical leave, if you fall under it with the paid family medical leave, with parental leave, and what have you. In addition, I'll talk about private plan options. Hopefully, most of you at this point have at least thought through whether you're going to go through an insurance company to meet your obligations for purposes of paid family medical leave versus going through the state. And I will talk about what those options are. I'll talk about the key deadlines and remind you of some employee communication items that you need to address. So just briefly, as I think most of you are aware, Minnesota will be the 14th state to implement paid leave in the country. And when you look at the slide deck or the slide on the screen, you can see that most of the states that have adopted paid leave programs are either on the East Coast or the West Coast. And so this is typically something you'd see on the coast, although Colorado also adopted a paid family medical leave a few years ago. Minnesota has been touting itself as offering the greatest benefit to employees at the fourth lowest cost to employers and employees amongst the 14 states. And we'll talk about what that means as we get into today's webinar. So the first question that many of you may be asking is, just as a refresher, what type of leave is protected? What type of leave is entitled to the benefits for purposes of Minnesota's paid family medical leave? And so there are essentially two types of buckets of leave. There is paid family leave and there is paid medical leave. So paid family leave allows an individual to take time off for bonding, so to care for a newly born child, for active duty, military reasons why they have to be off, for military as a result of a family member being re-engaged in the military, to care for a family member with a serious health condition, or uh, for safety leave, and safety leave is as a result of having to undergo treatment or seek assistance as a result of a domestic abuse, sexual assault, and what have you. And so employees are entitled to take up to 12 weeks of time off for paid family leave. And then in addition, they can take 12 weeks of paid time off for their own serious medical condition. I'm not going to spend time getting into the definition of what a serious medical condition is for purposes of today. But in essence, what you need to know is that in order for an individual to have a qualifying condition, that condition, except for bonding leave, must last more than 7 days and be certified by a healthcare provider or a designated professional in the case of safety leave. With regard to the two leaves, employees are entitled to a maximum of 20 weeks in total. And with regard to who a family member is that they can seek time off for to help care for, a family member is defined as a spouse or a domestic partner. It includes a child, whether it's biological, adopted, a foster child, or a stepchild. It includes a parent or legal guardian of the applicant, a sibling, a grandchild, grandparent or a spouse's grandparent, a son-in-law or daughter-in-law, and then an individual who has a relationship with the applicant that creates this expectation and reliance that the applicant cares for the individual, regardless of whether they reside together or not. So when you look at the definition of a family member for purposes of Minnesota's paid family medical, it is not as broad as the Minnesota Earned Sick and Safe Time. If an individual is eligible for paid family medical leave, assuming that you're going through the state program, uh, DEED is responsible for administering that program. And under the program, benefits will be paid by the state to individuals, and the benefits will be considered taxable income to the employee. And then keep in mind that you, as an employer, can generally pick the definition of the benefit year with regard to when does the year run for purposes of the employee commencing a 12-week leave program under either of the benefits. So when does an employee get to use paid family medical leave? Well, the qualifying condition must last uh, 7 days more, and it's got to be certified by the healthcare provider or designated professional. We're still waiting for DEED to draft a model certification form that the healthcare provider will sign off on. We haven't seen those, but one thing to keep in mind, to the extent that you have a diverse workforce, foreign providers may certify medical conditions. So as an example, if you have employees that are from uh, uh, Mexico or elsewhere in South America, a foreign provider could certify the individual as having a serious health condition, and that would be sufficient for the employee to use for purposes of seeking paid family medical leave. The minimum duration of benefits is generally one work day in a work week, unless we start getting into intermittent leave. So with regard to intermittent leave, uh, there's a little bit of ambiguity with regard to intermittent leave. The law says that the intermittent leave must be taken in increments consistent with the established policy of the employer to account for use of other forms of leave, so long as the employer's policy permits a minimum increment of at most one calendar day. And I think depending on who you talk to, you'll probably get different information with regard to whether you could have intermittent leave at 1 day increments versus do you have to allow employees to take intermittent leave at 15-minute increments. And my view is that the intermittent leave was probably at 15-minute increments because that's what you're required to do under the earned sick and safe time laws. And many of you have probably adopted paid time off policies that comply with earned sick and safe time, and you're allowing the individuals to take intermittent leave or take earned sick and safe time in 15-minute periods. The second thing that you need to consider with regard to intermittent leave is you have the ability under the paid family medical leave to limit the amount of time employees may use as intermittent. So the law says you may limit intermittent leave to 480 hours in a 12-month period, and that's essentially somebody taking 12 weeks of intermittent leave. Keep in mind, as I said earlier, the law allows employees to take up to 20 weeks of intermittent leave or 20 weeks of combined family and medical leave. And so if you do not draft a policy that limits intermittent leave to 480 hours, the employees would be entitled to intermittent leave for the entire period of time. So some of you have probably been asking, are we excluded? Can we seek to be excluded from the paid family medical leave law? And the answer is, for purposes of today's audience, it's highly, highly unlikely that you're exempt. Most employers are required to participate in the paid family medical leave program. Local government and municipalities are required. If you have fewer than 30 employees, there is assistance for small employers with regard to their premium pays, and I'll cover that momentarily. But the other question that often comes up is, okay, well, which employees are going to be entitled to use benefits for purposes of paid family medical leave? And frankly, the answer is most employees are going to be considered covered employees. So it includes full-time, part-time employees, it includes seasonal employees, owners, officers who draw salary, agricultural workers, and you can see the list goes on and on. But for purposes of today's audience, your full-time, part-time workers, seasonal workers are going to be covered. And you can see that I have on this slide that it's most seasonal employees. Well, to the extent that seasonal employees are not covered, it really relates to the hospitality industry. And it's a pretty narrow exemption for the hospitality industry. So I'm not going to get into that issue in light of today's audience. So who's not covered and who can cover it, who can opt in? Well, who's not covered are independent contractors, self-employed individuals. They're not covered, but they can opt into the paid family medical leave. And then those that are not covered and can't opt in, federal government employees, exempt seasonal employees, which I talked about briefly, which are the hospitality type employees that are exempt, and then railroad employees, which again does not cover today's audience.
Tom, there was a question in the chat asking if our commission only employees covered.
Commission only employees are covered.
Thank you.
Second is many of you may have employees that are working in different states, going from state to state, and the paid family medical leave provides a test to determine whether an employee is subject to paid family medical leave. And so the test is fairly basic, but it essentially says that employees who work 50% of more of the prior year in Minnesota are covered. So as an example, if you have Iowa employees that are spending 50% or more of their time in Minnesota, they're going to be covered by the paid family medical leave. If you have Iowa employees who are coming into Minnesota but are only spending 10% of their time, they are not going to be covered. And then in addition, you may have individuals who did not work 50% or more of their year in any one state. So let's say that they spend 40% of their time in Iowa, 30% in South Dakota, and 30% in Minnesota, but they live in Minnesota. they will be covered for purposes of paid family medical leave. Let's assume that you have a person that is a remote worker. A remote worker lives in Minnesota, but all their transactional work is for work in Iowa. Well, they're still in Minnesota, so they're going to be covered. And with regard to individuals who work in Iowa, they're remote in Iowa, maybe they transact work in Minnesota. I believe that DEED has issued guidance that those individuals, because they don't reside in Minnesota, would not be covered. So, how do employees become eligible for paid family medical leave beyond meeting the fact that they have a serious health condition or they meet one of the other criteria for paid medical or family leave? Well, in order to be eligible, they must have earned at least 5.3% of the statewide average annual wage in the past year. So they have to have earned at least $3,900 based upon 2025 numbers. If they've earned that much, they are eligible for the benefit. Second is, well, what are they entitled to? Well, they're entitled to up to 90% of their regular wages, up to a maximum of $1,423 per week based upon 2025 numbers. Now, you're going to have a lot of employees that, the maximum they'll receive is $1,423, but it will not cover the difference between what they normally make when they're working versus what they would work, versus what they would receive under paid family medical leave. And so oftentimes the question will become, well, can employees double dip? So as an example, can an employee receive unemployment and paid family medical leave at the same time? And the answer is no, they can't. Can they receive workers' comp at the same time as receiving paid family medical leave? And the answer is generally they're not going to be able to recoup both, but there are some theoretical scenarios where they might get a little bit from PFML depending on what their disability benefit is under workers' comp. And then finally, they're not going to be entitled to Social Security benefits and also receive paid family medical leave. And I'm going to talk a little bit later on in today's presentation with regard to what do you do or what can you do with regard to employees who are receiving less under paid family medical leave than what they would normally earn, and what you can do with allowing employees to supplement the benefit through paid time off, what have you. So if an employee is off on paid family medical leave, they're entitled to job protection if they've been employed with you for at least 90 days. An employee, if they've met that 90-day threshold, they're entitled to be restored to the same position or equivalent position with the same pay and benefits as they had prior to the leave. Another question that oftentimes comes up is what happens if an employee it leaves the company for whatever reason? Are they still entitled to paid family medical leave? And they are up to a certain period of time. They could still collect PFML benefits even after they leave your employment. So what is required of an employer? So very quickly, cover some of these in more detail, but there are three things that are certainly required. Payroll deductions, if you are deducting from employees' pay, they're sharing in the cost of the PFML premium. That'll take effect January 1st, and you'll have to start making your premium payments April 30th of 2026. You've had wage reporting requirements that started October 30th of last year. They'll continue. And you need to designate a paid leave coordinator, somebody who is going to actually have access to the state's portal if you're going through the state plan. You'll have an obligation to inform employees as to their rights under the paid family medical leave. One is you'll have to notify them as to through workforce posters that have been published. I'll show you one in a moment. And then you'll also have to do an individual notice by letter that the employee acknowledges receipt. And then finally, you'll have a duty to coordinate leaves with employees and also work with them in returning to work. So first, with regard to reporting of wages, at this point, hopefully, everybody has been reporting their wages. The paid leave program is using the same online reporting system as unemployment insurance. Your wage reporting is due on a quarterly basis. And I think the good news is that as of February 1st of this year, you can see that there are a significant number of employees that had been reported as being employed in Minnesota through the online portal. More than 3.4 million employee records were reported. So that is a good indicator that most employers have been compliant with their wage reporting requirements. And then as of January 1st, you'll be able to deduct up to 50% of the premiums from the employee's paycheck. So the premium through the state program is 0.88%. And so you could deduct up to 0.44% from the employee's paycheck. Now, a question has arisen with regard to some employers have already gotten their quotes for the insured program. The insured program is less. So let's say the insured program is 0.60 versus a state program of 0.88. And I've had employers ask, could we charge the employee 0.44% because that's not greater than what the state premium is, and we pay the rest. And there's a lot of conflicting information out there with regard to whether you can do that or not. My view is that you cannot do that, that you'd have to split the 50-50 premium through the insurance company with the employee. So you'd pay 0.3% and the employer would pay 0.3%. But there has been inconsistency. I think the law says that you have to share the cost as the carrier provides it. I know there's disagreement with others. And then as I noted, for employers with 30 or fewer employees, where the average employee wage is less than 150% of the statewide average annual wage, you're entitled to a reduced premium. That's so the average wage at 150% was $107,016 using this year's numbers. So just to cover the premiums again, so the starting premium rate is 0.88, maximum employee contribution is 0.44%. The employee weekly contribution, the maximum is that you can require them to pay is $14.90. And as I said, their maximum benefit is $14.23. And then you have the contribution rates for small employers. The minimum is 0.22%, but it's going to be dependent on what the state does. So I've talked about how you qualify as a small employer, and then there could be additional funding up to $3,000 if you're hiring temporary workers or you increase an existing employee's wages to cover the employee while on leave. Another item that I talked about that you need to do, and hopefully everybody has done this by now, but it would not surprise me if there are some of you in today's call that have not done this, and that is you need to set up a paid leave employer account. And there are instructions on the deed website on how you do that. But essentially, the paid leave employer account is where you as an employer will have the opportunity to review the leave applications that are filed by employees, and you'll have the ability to find the leave determinations that are issued by the state. Additionally, as you set up your employer account, you'll need to designate who is the paid leave administrator. In other words, who's the individual that's going to have access to the employer account. And that's the individual that will manage the account with the paid leave. They're the individual that will have the opportunity to review employee applications. They'll be able to coordinate paid leave with other benefits. And importantly, to the extent that you're looking at a private plan, an insured product, or perhaps you're even considering being self-insured, which is probably unlikely, it is on the paid leave employer account where you need to request an exemption. So if you have moved forward and you have decided that you're going to go through the private plan process, you still have to request an exemption from the state. The state will ask that you upload the policy, the insurance policy that you have for their approval. And they are asking that you provide that information by November 10th so that they have time to approve the exemption. Otherwise, you're going to default to the state program. It's also on the paid leave employer account where you can apply for small employer assistance funding. So some of you may be wondering, well, how does this paid leave application process work? Well, if you go through the state, essentially the employee is required to first notify you, the employer, about their intentions to take leave. And the state has indicated that they will not process applications until the employee has actually notified you of their intentions to take leave. Additionally, this is where your policies have to be clear with regard to how much time employees must give you to notify you as to the need for time. And generally speaking, you can require that the employee provide you up to 30 days advance notice of the need to take time off. And of course, if there are unforeseeable circumstances, they can provide you that notice as soon as practical. Once the employee notifies you of their time to take time off, then the employee can start an application through the deed process. And the paid leave administrator for the company will be notified that an application has started. Once the employee submits the application for paid leave, the paid leave administrator will likely receive a request for information from the state for the administrator to respond to. And from there, the paid leave division will determine the outcome of the claim, and both the employee and the company's administrator will be notified of the decision. And for the insured products, if you go through the insured products, there's going to be a very similar process through the carriers. So some things that you need to think about it, and hopefully many of you have already started thinking about this, but one item is, are you going to allow employees to top off paid leave? In other words, allow them to supplement what they're receiving through the state PFML. And that's a decision that you can make. So you can make a decision to allow employees to top off paid leave with sick time, with vacation, with paid time off, short-term disability, so that they can essentially return to an income level of what they would have received but for going off on leave. And that's a decision that you can make. Secondly, employees can make a decision that they want to use paid time off or earn sick and save time in lieu of PFML, and assuming that they're taking time off for an event that qualifies under the paid family medical leave, that time that they take, even though they're using a different benefit, would still be counted towards their total PFML allotment. So if they take 2 weeks of paid time off for their own serious health condition, they have exhausted 2 of the 12 weeks that they're entitled to take. And so some of you may ask, well, why would somebody do that? Well, one reason an employee may do that is because they think that it's going to be easier for them to get the benefit right away. They may take the PTO just because they view it as this is an opportunity for them to get the full pay quickly without having to wait for the state to respond or the insurance carrier to respond. But bottom line is, with regard to allowing employees to top off, that's your decision. With regard to employees being able to use paid time off for PFML reasons, they're entitled to do so, and you don't have a say in that. So as I said before, you're going to have to notify your employees of their rights under paid family medical leave, and you're going to have to do that by December 1st. So first, you'll have to post the PFML poster, and this is what the poster looks like. That poster is now available on the deed website. You can download it and you can post this now if you wanted to, but it has to be posted by December 1st. Second thing that you have to do is you have to notify individual employees directly in their native language within 30 days of their hired of their PFML rights, or you got to do it by December 1st if they're currently employed. And paid leave is in the process of developing a model notification letter, and they'll make that available in multiple languages for you to distribute. I understand that's going to be posted or put on the website in the coming weeks, so we should see that fairly quickly. And in addition, you need to have employees affirmatively acknowledge receipt or otherwise be able to demonstrate how individual employees were notified of their rights under PFML. The other thing I want to make note of is, to the extent that you have a diverse workforce, with regard to the poster as well. That poster, if you have 5 or more individuals speaking a language other than English, you have to post that poster in the language of that particular group as well. So the questions become, well, how do we start preparing for this? And what do we do? And what should a paid leave administrator do as they start preparing for paid family medical leave? And so first and foremost, there's a whole host of different benefits and leaves that are available. And you have to start thinking about coordinating these leaves and making sure that your policies are addressing the coordination of the leaves. So some of you, and not all of you, may fall under the Federal Family Medical Leave Act, which is a federal program that entitles eligible employees to take unpaid job protected leave for specified family medical leave reasons. And you can run PFML and federal FMLA concurrently to the extent that the types of leave fall under both acts. Additionally, with regard to Minnesota parental leave, PFML does not replace the Minnesota Parental Leave Act, which allows employees to take up to 12 weeks of unpaid leave. But keep in mind that you can run Minnesota parental leave and PFML concurrently. And again, something that your policies should be addressing. So the leaves can be run concurrently if they're taken for the same purpose allowed under the various statutes. So you can require employees to run FMLA and PFML concurrently, and you cannot force employees to take earned sick and safe time for purposes of paid family medical leave, but employees can decide to do so. Now, sometimes employers will ask, help us understand the difference between earned sick and safe time and PFML. And so we put together a couple slides that outline, the differences between the two laws. I'm not going to go through each and every item here, but it will help you focus with regard to some of the differences, as far as covered employees under earned sick and safe time. They have to have been reasonably anticipated to work at least 80 hours for you, and they're covered. Otherwise, for paid family medical leave, as I said before, they have to earn at least 5.3 of the statewide average annual wage. And then the leave amount that the employees are eligible under the two statutes is obviously different. And then, of course, how it's funded is also different. And then, qualifying reasons. Earned sick and safe time has much broader reasons for why employees can take time off versus under paid family medical leave. But you can also see that there are a lot of similarities as to what employees can use, or what similarities as to the types of leave that employees can take under the two different statutes. There may be some of you that are a union workforce, and so one question is, what do we do with union employees? Well, I think there's a few things. You certainly would have a duty to bargain with the union with regard to the premium sharing. So if you're looking at a split of sharing the premium 50-50, that is, you're going to have to negotiate with the union with regard to that sharing. A state plan versus an insured plan versus a self-insured plan. There's a potential issue that you have to negotiate over whether you're going through the state plan or insured plan, depending on whether there are differences between what the state plan provides versus the insured plan, which could provide a greater benefit than the state plan. And then, of course, as we talked earlier, you have you're going to have to decide whether you're going to allow employees to top off their benefits or not, and that would be an item for bargaining as well with the unions. So equivalent private plans, I'm not going to spend a lot of time on an equivalent private plan, in part because as you're going through this process, if you are looking at going through an insured product, and quite a few employers are going through an insured product because they're finding that there is a cost savings. Those insured products have to be first improved by the state before they can even go to market. And there are roughly 19 insurance companies that have been approved to offer insurance, PFML insurance through the state. So there's 19, and quite a few employers have already started to file for the exemption through the state. In July, I think there were only 4 employers that had sought approval through the state, and 2 had been approved and 2 were waiting for approval. And I think that number is up to 100 now that have sought approval. I can tell you that, most employers that I'm talking to, they're going through a private plan, but not all. And if you go through the private plan, one thing to consider is whether or not you can sign up for the private plan for more than 1 year. I've had some clients tell me that they were able to sign up for a private plan for a couple of years to lock in the premium rate for a 2-year period versus a 1-year period. But bottom line is, for the private plans, which I'm referring to as insured plans, they have to meet the same obligations under the paid family medical leave as what is provided through the state program. If you're going through and you've decided that you're going to self-insure, which is also considered a private plan, then your plan must meet or exceed the coverage requirements under Minnesota law. And there's quite a few items that you have to meet, including that the leave time is available both to current and recently separated employees, that the payment rates are at least as great as what the state law would provide, that the employees have job protection. The bottom line is, when it comes to an equivalent plan, uh, you know, don't think just because you have a short-term disability plan that you're meeting the PFML requirements. Don't think just because you have a paid parental leave policy where you pay for 12 weeks that you're complying with the private plan requirements. You're not. So you can see that there's a lot of misconceptions on this slide as it relates to private plans. You need to make sure that whatever you're doing has been approved by the state. And if you're looking at going through and doing self-insurance, there are a number of items that you need to meet as a self-insured plan. There is guidance from the Department of Commerce as far as what is in fact required. And I'll just, without going through each and every bullet point on this slide, in the next slide, I'll just point out that you can reference these in the future if you have questions on setting up a self-insured plan. But like I said, I'm not aware of any employers yet that have looked at setting up a self-insured program. I think it's pretty onerous for an employer to do, and I would suspect that there's only going to be a few employers that do actually set up a self-insured program, and likely it's going to be some of the Fortune 500 companies that have operations in the state of Minnesota. Regardless of whether you have you go through the state or you go through a private plan, goes without saying that the statute prohibits retaliation, and employers cannot discharge, discipline, penalize, interfere with, threaten, or coerce employees as a result of them seeking or requesting or obtaining PFML benefits or exercising their rights under the statute. And of course, it goes without saying that employers cannot obstruct or impede an individual from applying for PFML leave benefits. So some common things to or deadlines, just as a reminder, November 10th is where the state is asking that if you are going to go through a private plan, you need to submit by November 10th to ensure that the state has an opportunity to view and approve the request for the exemption for you to go through a private plan. And then, of course, as I said earlier, you need to notify employees about paid leave benefits by December 1st. Payroll deductions start January 1st. Benefits and leaves are available to Minnesotans as of January 1st. Common question that's being asked now is, well, what if I have an individual who takes time off now and that moves into next year? Are they entitled to PFML as of January 1st? And the answer is yes, they are, assuming that they meet the eligibility requirements. Small business assistance funding is available as of January 1st, and you have the quarterly premiums due April 30th. So, so what do you do between now and the end of the year. So here are some things that hopefully you started to think through. But one is, who is going to be your paid leave administrator? Probably it's going to be somebody in HR, and to the extent that you don't have an HR department, it's going to be somebody, is probably going to be an owner or the manager of the business. Second item is you need to determine what the minimum increment of time you'll allow for purposes of intermittent leave. Is it going to be 15 minutes? Is it going to be a full day? Two, are you going to allow employees to take intermittent leave beyond the 480 hours that you are required? And then three, start looking at your policies and procedures. I mean, I know typically right around now is when employers start looking at their employee handbooks and their employment policies. And now is the time for you to start reviewing your existing leave policies, including your paid parental leave and the notification requirements, and making sure that you're updating your existing leave policies, but also drafting your PFML policy. And so that employees are aware of what the usual and customary notice requirements are for employees to notify you of their need for leave. And as I said, you can require that the employee provide you with at least 30 days notice before the leave begins, except in those scenarios where notice is not possible and they need to notify you as soon as possible. But my advice to employers is, now's the time to have your policies reviewed and updated. I would caution employers, to the extent that you work with legal counsel, to have your policies and procedures updated. You probably want to reach out to them sooner rather than later, because I think this is going to be one of those years where uh, employers are going to wait till the last minute to have their policies updated, and it's going to be hard for your professionals to get back to you as quickly as possible, because everybody's looking for updates. The other item is determine whether to apply for a private plan. My advice is, I think it makes sense for all employers to look at whether a private plan, an insured product, makes sense for you, and then make a decision based upon what the quotes are from the insurance carrier. Some will say if you don't like the state unemployment system, you're not going to like the state paid leave program. Others will say, look, you know what, if we have the state handle it, it's just less administrative burden for us. I'm not sure that it is less administrative burden than working through an insured program. But certainly there's a lot of items for you to think about as you start getting into compliance with the Minnesota Paid Family Medical Leave. As I told, I guess I have a couple other items for you to consider. One is determine whether to allow employees to top off PFML. So you have to decide whether you're going to allow them, uh, allow employees to use PTO or other benefits to top off their PFML benefits. You'll have to decide how much you'll pay towards the paid leave premium, whether you're going to pay 100% versus 50%. I'll note that there is some tax guidance with regard to the premium co-share. And if you pay 100% of the PFML benefit, there is a tax consequence to the employees that is treated as income to the employees. So they're still going to be taxed. And that may be one reason why you decide that you're going to share the cost with the employee. But that tax guidance is available on the DEED website for you to look at as well. The other thing to think through and start getting into compliance is making sure that you're working with whoever your payroll provider is, or if you have an internal payroll provider, is working with them to ensure that you have the appropriate infrastructure in place to support PFML, and to make sure that you're amending your employee earning statements so that they do actually indicate what the deductions are for the PFML premium. And then, like I said, you know, make sure you're reviewing your handbook and your policies, including how your current federal FMLA policies will be affected under this new law. And so finally, as a note, October 31st, you were required to start submitting your quarterly wage reports. You should be doing that December 1st. Make sure you get the posters posted, employee notices out January 1st. You can start deducting the employee share of the premium, and then your first premiums are due to deed by April 30th. So I left a few moments for questions. If any of you have questions, I'm looking in the chat box now. Uh, so just let me know if you have questions. Okay, so I'm not seeing any questions. So to the extent that you do have questions in the future, feel free to reach out to me. Be happy to answer your questions on a courtesy basis. If you just shoot me an email and tell me that you're at this webinar, I'll answer your question to the extent that I can as a courtesy. Otherwise, I'm not seeing any other questions. So thank you
I'm
very much for your time.
I'm not seeing any either, Tom, and there is nothing put in the chat, nothing put in the Q&A. And so thanks, Tom, for all that information today. We really appreciated it. And I'll make sure that your email is also shared. And just so you know, this webinar has been recorded, and we will send out the recording later on today or tomorrow.
Thanks, everyone.
Thank you so much. Have a great day.